Good afternoon. So nervous, but I have the green lights on the microphone, so Alan said to go for it instead of the shitty thing on there. He's feeding the pigs. He'll be right back. I know that I left off at 12, page 12. What I'll do is share screen there. And just to let you know, kill time while he's coming back. I'm like, when am I going to do this? I'm like, well, it's 103 out, so I'm not going to throw the ball for Goldie. I usually do that and work on my Spanish grammar. The watercolor painting that I started may or may not get finished. I wanted to wash the dishes and do another load of laundry before I hit the road and listen to my Spanish lesson, read my Spanish graded reader. So why do all that when I can re-record this video? Maybe it'll be even better. I tried to look at the captions to see if I could even see, like, on YouTube, because it has to be stored on YouTube, if I could see the captions and maybe I could just read off the captions. But anyway, there was a lot of rants from Alan because he and I, well, it's not that we don't see eye to eye. It's just that I put forth the information and it triggers him. He just doesn't agree with it. Doesn't agree with just aspects of our system. He just hates it. He doesn't like it. So I'm going to share, keep my eye on the mic. Maybe I should turn off my phone. Sorry. Turn off my phone so it doesn't do anything to, I don't know what it does, just in case, okay? And then we're going to get going. Sorry about this. I should have thought about this before. This phone turns off funky. I don't know how to do it. Power off, okay? No chances. Taking no chances. No chances. All right. Share file. Share screen. Oh, please, I hope this works. Ripple, order, share. Okay? Let's see how this looks. All righty. There's no place for me to confirm that voice is being recorded other than on this mic. So there you go. Oh, look. Oh, I see. I just learned something. You bring the document to the room just like you would bring the document, like a person. All right. Learn something new. Here we go. Here we go. I'm screwing around. 12. I was only on 12. That means I was about to, I haven't gone very far. So what I had done, where was I? Oh, the essential ingredients test. And it focused on the investor's expectations of profits from the efforts of other rather than formal imposition of post-sale obligations on the promoter or the grant to an investor of a right to share in profits. Citing Howie, the Supreme Court's use of the word profits in Howie was intended to refer to income or return. That was Edwards. That was a case that I was going to get back to confirm that that's actually what it said, because I thought, wow, that's not a good fact for Ripple. Remember when I did on the 3-part series, I did I don't know if I mentioned this. Forgive me if I repeat something that I mentioned in 11 minutes, but I put some in the SEC column and I put some in the Ripple column. I said that's a win for them. That's kind of a win for them. That's why I thought it would be difficult for her to decide, but the overarching facts she didn't buy the essential ingredients, although this came up in other aspects. But financial returns on investments are not equivalent to post-sale obligations. So a lot of the Twitters and the tweets and everything said, but how could anybody sue them and this and that? Well, she's saying it doesn't matter. And look at this Edwards case. Thus, the court is not persuaded, okay, by this essential ingredients argument. And on we go, okay? So here we go. We're at page 14. Don't despair. It's not that bad. The XRP token. Okay. This is her. We're now at her. Well, you know, because I must have explained it before. Should have listened to the 11 minutes. Lazy. Okay. analysis. A, the XRP token. The plain words of Howie make clear that an investment contract for purposes of the Securities Act means a contract, transaction, or scheme. I'm going to have to remember now, having to re-record this because I don't do it on notes. I wing it, of course, as Wayne would say. That keep that in mind. What is a security? It's an investment contract or some other kind, but investment contract is a way that something can become a security. The security is the investment contract. We're going to see this below in the way that she describes this, in a manner in which I think that you can wrap your mind around this and really embrace her ruling, even though Ripple lost 1 out of 3. Okay. Which is actually pretty good batting average, isn't it? So, oh, this is it. Okay. But the subject of a contract, transaction, scheme is not necessarily a security. The subject of the investment contracts, contracts, transaction, or scheme. So what I had emphasized was this subject is the coin, the digital asset, the token, the orange, the chinchilla, the whiskey. Okay. And everybody gets all wrapped up into saying, is XRP a security? XRP, no, the subject of some kind of a contract is not the security. The security is the investment contract, the transaction or scheme that it becomes. And you're going to understand this again even better by the language she continues to use. Under Howie, the court analyzes the economic reality and totality of circumstances surrounding the offers and sales of the underlying asset. She's citing here to a United States Supreme Court case and another. Glen Arden is the whiskey case. I can't remember the district, but this is a citable, not a citable, a binding authority if it's from the second district, okay? Appellate court. Howie and its progeny have held that a variety of tangible and intangible assets can serve as the subject of an investment contract. And if there's anything I want you to take away from this video, you could just see this part and check out, okay? Because this is the essence of everything you need to know about all this kick in the coop about, is XRP a security? It's really the wrong question. Okay. No, it's not. And we as a community, not me so much because I've only been doing this for 2 months, but the community itself has just driven themselves mad with this question. Okay. The subject of an investment contract: Howie, Orange Groves, Glen Arden Whiskey, Edwards Payphones, Hawking Condominiums, and this one Beavers, and this one Digital Tokens. Telegram, okay? Telegram already found that the subject of the investment contract is never the security, okay? So there's no big reveal, there's no big settlement of the issue from this case. It's already done by all these cases from whatever years they are, 1989, 1990, 1967. It's already decided, okay? And you can go back and look at some of the videos I did. I did 2 separate videos on secondary market. Is there some kind of a problem here? In each case, I said no. In each of these cases, the subject of the investment contract was a standalone commodity. The subject of the investment contract, I'm going to harp on this, and so does Judge Torres, which was not itself inherently an investment contract, okay? Not itself inherently an investment contract. For instance, if the original citrus grows in Howie were later resold, those resales may or may not constitute investment contracts depending on the totality of the circumstances surrounding the later transaction. Okay? Here, defendants argue that XRP does not have the character and commerce of a security and is akin to other ordinary assets like gold, silver, and sugar. This argument misses the point because ordinary assets like gold, silver, sugar may be sold as investment contracts depending on the circumstances of those sales. Okay? Even if XRP exhibits certain characteristics of a commodity or a currency, it may nonetheless be offered or sold as an investment contract. This is important. It's never the security. It never was. It never was at risk for being one. As another court, here comes Alan now. Or no, he needs to get something to drink. As another court in this district recently held, while helpful as a shorthand, this is from Telegram, we went over this as well. While helpful as a shorthand reference, the security in this case is not simply the digital token, the gram, which is little more than alphanumeric cryptographic sequence. This case presents a scheme to be evaluated under Howey that consists of the full set of contracts, expectations, and understandings centered on the sales and distribution of the gram. Howey requires an examination of the entirety of the parties' understandings and expectations. So to say that we finally have the clarity that we've been looking for to know that whether XRP in the secondary market is a security as a standalone commodity. No, we already had it from the Telegram. And by the way, this judge is down the hall from Judge Torres. XRP as a digital token is not in and of itself a contract, transaction, or scheme that embodies the Howey requirements of an investment contract. Rather, the court examines the totality of the circumstances surrounding defendants' different transactions and schemes involving the sale and distribution of XRP. Marine Bank versus Weaver, another United States Supreme Court case from 1982. Each transaction must be analyzed and evaluated on the basis of the content of the instruments in question, the purposes intended to be served, and the factual setting as a whole. Shorty's got to go. Come on, Jordan. Come on, Jordan. You're okay. Okay. And all right. Okay. So that I just think is very powerful. Like I said, if you needed to just take one thing away from this case, it would be this. Also combined with programmatic sales ruling, which I believe, again, just bolsters the fact that we have nothing to worry about. We just like to beat dead horses over and over again. So defendants offers and sales of XRP. I don't see the word XRP holders here. I don't see anything other than defendants. That means Ripple, Garlinghouse, Larson. Here's what they allege. I'm only going over this again just so you know if these were how the judge was gonna divide this up. Let me just make sure we're on track here. Good. Okay. And green. That's good. Let me make this bigger. Okay. So this is how she structured her ruling. So we're just going to refresh our memory on this. We went over this a couple times together in the videos that I did. So SEC allegations, institutional sales or securities, programmatic sales on digital asset exchanges for which it received $757 million, securities and other distributions under written contracts for which it recorded $609 million, securities. Okay, that's their allegations. You'll see written contracts here, written contracts here. Okay, both didn't matter. The contract, the writing of something didn't matter. Okay. The SEC also alleged that Larson and Garlinghouse engaged in unregistered individual XRPs for $50 million. She's going to get to that. Okay. Institutional sales. I'm consciously trying not to race because I feel like you've already heard it, but you haven't already heard it because you didn't get this far.
For you non-lip readers in the crowd.
Seriously, I was trying to I was hoping that the CC thing would work, but it didn't. First, addressing institutional sales to sophisticated individuals and entities, the institutional buyers pursuant to written contracts. Okay, this is important so that you can finally put to rest that the SEC has not brought a frivolous action against Ripple on this basis. Okay, remember, the SEC only won 1 out of the 3. Okay, and programmatic sales, by the way, probably was a close call for the judge. The third one was probably a no-brainer. But this one, I believe when you see this, maybe it'll put your mind at ease that everything is all right with the world. Judge Torres is sharp, as I've said all along. The ruling proves that to me. So the first prong of Howey examines whether an investment of money was part of the relevant transaction. They invested money, okay? And defendants don't dispute that Ripple received the money or there was an investment of money. Sorry, the dog now is bugging the cat. Okay, you're gonna knock over my drink. Leave her. Okay. Defendants argued that an investment of money is different from merely payment of money. Wow, like just a really bad argument. Okay, I guess they're just grasping at straws there, but if they concede one, then maybe it's tricky at the rest of the case, but not so. Purported distinction is not supported by case law, provided the capital. Okay. Defendants do not dispute there was a payment of money. The court finds that element's established. Okay. Don't want to spend too much on that. The second prong of Howey, the existence of a common enterprise. This is where I thought maybe the issue was trickier. She's citing REVAC. We've gone over REVAC 328 US, the United States Supreme Court case. What I said is she's backing up a lot of her ruling with United States Supreme Court cases, along with some persuasive authority, may be demonstrated by a showing of horizontal commonality. She says she doesn't have, number one, the Second Circuit has not addressed whether strict vertical commonality theory can give rise to a common enterprise. We also discussed that in the 3-part series. But anyway, she's saying here that because she's going to find horizontal commonality, she's not going to deal with vertical. Okay. So I'm sorry, I went too far. Here we go. And we know this, we studied this. Horizontal commonality, where investors' assets are pooled and the fortunes of each investor are tied to the fortunes of other investors, as well as to the success of the overall enterprise. And we studied this case as well, SG Limited, although it's a First Circuit case, and pooling of assets and sharing the profits and risks of the enterprise. So when you look at the contracts between Ripple, checks were written to Ripple by these investors, and that's what makes it different, I think, from the programmatic sales in part. Here, the undisputed record shows existence of horizontal commonality. Ripple pooled the proceeds of its sales into network of banks under the names of various subsidiaries. Ripple again made a very, whatever they could argument to say, well, we had them in separate bank accounts, and the court was not going for that at all. Okay. Each institutional buyer's ability to profit was tied to Ripple's fortunes and the fortunes of other institutional buyers, because all institutional buyers received the same fungible XRP. And this was an important footnote that I had highlighted. The court holds only that a common enterprise existed between Ripple and the institutional buyers. The court does not reach the question of whether the common enterprise extends to encompass other XRP holders, defendants Garlinghouse and Larson, the XRP ecosystem, or any other entities. And that's basically just putting the kibosh on all those amicus briefs. So where was I? Oh, I was at the footnote. Ripple used the funds it received from its institutional sales to promote and increase the value of XRP by developing uses for XRP and protecting the XRP trading market. And this is the citations to all the evidence she's relying on for that. When the value of XRP rose, all institutional buyers profited in proportion to their XRP holdings. And that's that pro rata stuff that we learned about. And she's citing Kick. And one thing she does, unless it's truly a conclusion or something that's sort of just a reasoning, a rationale, or a thinking about it, she cites evidence or law throughout the whole thing. So she relies on a lot of persuasive authority, but she can. So the success of the ecosystem drove demand for the digital token KIN and thus dictated investors' profits. Telegram finding horizontal commonality where the digital token purchasers possess an identical instrument, the value of which is entirely dependent on the success or failure of the TON blockchain. Fortunes are directly tied to the success of the TON blockchain as a whole. The court finds Judge Torres the existence of a common enterprise because the record demonstrates there was a pooling of assets and the fortunes were tied to each other. Not an extensive analysis. Maybe there's some room there to challenge it. But again, she does have citations here, and she is only talking about the institutional investor. She's not talking, as she's specified, about anybody else. So the third prong of Howey examines whether the economic reality surrounding Ripple's institutional sales led the institutional buyers to have a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. And this was that Foreman case that we never got to, but again, another United States Supreme Court case from 1975. Okay. So, the fact that the law has been settled for a while is evident. In this context, profit means an income or return to include. And this was one of those things I talked about when I first recording, and also with you in the 3-part series, because I didn't get to Edwards in the way that I said, man, that is wild, that who extended that issue to profits, meaning beyond dividends, periodic payments, and who put this increased value of the investment. I thought, man, is that some kind of rinky-dink trial court? And no, lo and behold, it's a quote out of Edwards that she's relying on. So, that's the law. That's what the United States Supreme Court found, and that's what she's bound to use as well. The reasonable expectation of profits from the efforts of others need not be the sole reason a purchaser buys an investment. An asset may be sold for both consumptive and speculative uses, relying on library. All right. This podunk judge or whatever. Moreover, the inquiry is an objective one, focusing on the promises. I shouldn't call them that, but whatever. This is Patreon. Strike that. Focusing on the promises and offers made to investors. It is not a search for the precise motivation of each individual participant. Telegram. She cites here to Telegram, but Telegram relies on this more, not binding authority, as I stated before, but it's out of the Ninth Circuit, so it's an appellate court. Although, in all reality, I guess, in all fairness, it kind of sits in the same persuasive bucket as Telegram, so I don't know. But anyway, it's fine. Based on the totality of the circumstances, the court finds reasonable investors purchased it for with an expectation of making money. They weren't donating to a charity. Okay. Then she went into the evidence supporting this, the marketing campaigns, the reliance on the use of the capital to improve the market for XRP, develop uses for XRP ledger, increasing the value of XRP through Ripple's efforts, the promotional materials. She spent almost 2 full pages, I believe, is what we came up, more than 2 pages of evidence. So this appellate, is this going to be appealed issue? I don't know. I don't think so. You have to, as an appellate court, are going to take the facts in the light most favorable to the winner of this issue. And when you have this much fact cited in here, remember I made the distinction above with the common enterprise. I said it's kind of a light section. Actually, she kind of got in, got out. This one, she covered her bases here and cites a lot of evidence, a lot more than she did in common enterprise element. Maybe she finds that the common enterprise element is more straightforward than I do. I thought this one was more straightforward. Whatever. We don't.
Maybe she just had more evidence on this one.
Yeah, maybe that's why I just said this is an ad issue. It's common enterprise that it's going to rise and fall on. So there's lots of statements in here. There's a ton of evidence. Okay. There's no reason for me to really, I don't know, rub salt in your wounds. And so I kind of skimmed over this last time a little bit. I pointed out some of the ones that she picked out, but there's a ton more than this. She just picked the ones that persuaded her and that she thought would persuade a jury. So it's XRP's dramatic and stunning price increase notes.
I don't know why they would argue this anyway going forward.
This issue is, it's not, nobody's going to win. Nobody's winning this issue. Like Ripple can't, they could win maybe on common enterprise. Maybe. I don't know that they want to spend that 200 million, another 200 million to try and undo that. I don't know. Not sure. So, lots of stuff here. Just take my word for it. It's all here. Do we need to, go over it? Extensive capital. I was persuaded by this. I was persuaded by this when I read this evidence before this summary of her. I thought, well, this issue is kind of dead in the water for Ripple, I think. And that's why I spent so much time focusing on common enterprise, which I still feel is, I don't know. I don't know. I'm still an I don't know on it. I don't know why she was so clear. Maybe I'll dissect it again. I don't know.
In any of the evidence, did she have any quotes from Gary Gensler?
That was another thing. The big Hinman reveal, all the unredacted stuff. It's not in here.
Well, no, I'm not saying that. I just see Brad Garlinghouse every other sentence. And it's like, well.
But what Gary says is not relevant to whether Ripple took reasonable efforts to increase the value of the investment to the investment buyers.
No, that's true.
So for this element, no. That is the Gensler,
that's true.
Hinman stuff comes into fair notice defense. And YouTube video. I have no qualms saying definitively, if we continue to drive the success we're driving, we're going to drive a massive amount of demand for XRP, blah, blah, blah. Okay.
Yeah.
I didn't go over that much of it. Mostly I just highlighted it to show you that she's got a ton of evidence support this prong, and it didn't surprise me.
No,
too much.
I wasn't surprised. And like I say, they're not going to sell it like this going forward anyway.
That's right.
No need.
So when Ripple has no reason. I mean, we said, if the thing goes to $10, Ripple just takes their whatevers.
Brad's got 1 billion of them. What does he care?
Here's our pound of flesh that you wanted. And they move on. They get an injunction saying, Ripple, don't ever sell XRP as an investment contract ever again. And I go, okay, whatever.
Yeah.
Fine. I just don't see, there's no value to them in appealing this.
What this is on a deeper level is it goes back to fundraising, getting off the ground. It leads to, how do you start a business that has no revenue, and how do you get it out there as quickly as possible? And something as revolutionary as in 2017, a crypto, without going to an ICO. Okay, so that's what
borrowing money.
Yeah, or borrowing money, which is what Wall Street wants you to do, because then you're an indentured slave at that point. You're then stuck in the system, and you owe somebody a favor, and a monetary, not just monetarily. It's, oh, well, Goldman Sachs supports this or they don't. You're forever indebted. And that's what they're trying to preserve by going after them the way they did. They hate ICOs for the reason that you and I can create some code in our mom's basement, create a great idea, put it out on the internet, and make tens of billions of dollars of selling tokens, and they don't get anything for it. They don't get a nickel for it because we didn't borrow any money from them. So that's what this whole part of this thing was about. There's Goldie.
She wants her ball time, but
Yeah,
it's 103 degrees.
yeah, it's toasty out there.
So
guys.
she doesn't have a frontal lobe or whatever we call it. So she doesn't know. That's not good for her. The final thing I wanted to talk about is, are you good?
Yeah.
Further, the nature of the institutional sales also, this is another, but we use it for, it has utility. It's like, yeah, okay, but it doesn't matter, she says. Further, the nature of institutional sales also supports the conclusion that Ripple sold XRP as an investment rather than for consumptive use. In their sales contracts, some institutional buyers agreed to lock up provisions or resale restrictions based on XRP's trading volume. These restrictions are inconsistent with the notion that XRP was used as a currency or for some other consumptive use. Simply put, a rational economic actor would not agree to freeze millions of dollars if the purchaser's intent was to obtain a substitute for fiat currency. Telegram citing her there, certain institutional contracts, sales contracts required the institutional buyer to indemnify Ripple for claims arising out of the sale or distribution of XRP. So the indemnification, the freezing up, and other contracts said purchasing XRP to solely resell or otherwise distribute and not to use as an end user. Okay. These provisions in the institutional sales contract support the conclusion the parties did not view XRP sale as a sale of a commodity or currency. They understood the sale to be an investment in Ripple's efforts. Okay. So that's that third prong again, addressing all arguments.
Yeah.
All arguments that people raised.
I keep beating the dead horse, but
okay, you can.
The court,
it's your show.
The court and the SEC have met their match. They have no idea what they're dealing with. They're trying to judge a body of water when it's air, and they're trying to fit it into a body of water when it's air or oxygen. There's 2 or 3 of those sentences that are not accurate. I'm just like, well, wait a minute. Actually, it is consumed. Every time you transact an XRP, it's consumed. How can that not be a commodity?
She's saying, though, here, it didn't really, maybe if that was true, but she's saying in this case, they agreed to lock it up, freeze millions of their dollars.
Mm-hmm.
Okay. Indemnify Ripple for claims arising out of the sale and other things that said, I don't know. And also here, the quotes here. So she's just saying there may, I'm not saying never. She didn't say that.
Right.
But she's just saying the evidence in this case sort of cuts against that argument. And so, and a jury might have found differently, but she decided to go with this one.
I'm not arguing that point. I'm arguing the fact that not everything fits into their, like the future of, I don't know, it's hard to explain. I have kind of a detailed mind when it comes to crypto, and I've followed it since day one, and I really understand the ins and outs of it. So it's sort of like, are we going to ever be able to judge in the future AI as a human being? Are they going to get tried in a court of law as a human, or what are they going to be tried as?
If they commit any crimes. A corporation can be tried in criminal court.
My point is as technology evolves, some of these laws simply they're not appropriate, in my opinion.
Okay.
That's all I'm trying to say. They're
Sure,
not adequate.
show your opinion.
And to have somebody judge on something that they don't even understand what the product is really sort of, I don't know, it's crazy.
But she knows how to make an airtight ruling. That she does know.
Yes.
The footnote 15, I had wanted to highlight. I did highlight. The court holds only that Ripple sales of XRP to the institutional buyers were offers and sales of investment contracts to the extent the SEC instead argues that Ripple actually sold investment contracts to the public and used the institutional buyers as underwriters. The court rejects that argument. So she's taking care of that. And she's also going to take care of it down here in the programmatic sales. Okay. Next, programmatic sales. Ripple wins this one. You all know that, but it's important for everybody to understand this so we can all, as our viewers, not engage in the nonsense that goes on out there.
Let me get to the bottom of it.
In the YouTube.
It all makes sense to you, right?
It really,
this section.
So clear. Yeah.
Right.
And I'm thinking always in terms of the questions that get asked. Is this going to appeal? Could the appeal and everything else? And so I'm having to dig a little deeper behind the scenes into procedure and go, okay, well, if it's the light most favorable to the winner,
right?
How on earth is Ripple going to appeal this? Maybe on common enterprise because she's a little light on that. Yeah. And I tried to dissect that, or maybe that should have gone to something, but she's saying that Edwards case kind of, is it the Edwards case I said? I can't remember which case. No, the Edwards was the, I think it was the Edwards case. The profits. Common enterprise. Anyway. Your question has got me curious. I guess you asked me about my overall feeling. I guess my only issue, and maybe this is my own ego over it, but I really thought this was sort of the issue that shouldn't have got there. So look, I'm going to go here. Pooled, and the fortunes of each investor are tied to the fortunes of other investors. Typical commonality, pooling of assets, so all share in the profits. So the definition of profits is part of the horizontal commonality element, and then you go to Edwards for what profits is going to be defined as for a jury, and that's where you get to Edwards.
But we don't share in the profits. We don't.
Yes, under Edwards, because profits has a broad meaning that she said, and I said, I really didn't love it. I said, where did they all of a sudden come up with, or the increased value of the investment itself by the individual investor? And the United States Supreme Court case said way back whenever that, yes, it's A-okay. And I had said in my 3-part series that I was kind of concerned where this all of a sudden started appearing. And I think it appears from Howie, but anyway, that was I didn't love that. I still don't love that.
No, I don't either. That doesn't.
Because that makes a common enterprise, because she's saying in programmatic sales later that, blind bid ask, and I sell it whenever I want, and blah, blah, blah. So, you can't, you do the best you can. I mean, she's doing the best she can.
Yeah.
With this case.
That's what I mean.
Where I lost my programmatic
how broad
sales.
it is and how doesn't always apply.
I lost my programmatic sales.
I guess there is no perfect law.
There's nothing perfect in the world.
Yeah.
Nothing perfect.
What do you think? Well, I don't want to get you sidetracked.
Oh, it's all right.
This show will go on forever.
It's all right. We're ahead of the game here. We're okay. We're on programmatic sales. Sorry about all the scrolling. Are we still recording?
Yeah. It's green anyway. So, okay. So I don't think it's going to be an issue anyway. I mean, well, you've done a lot of appeals. Okay.
Not
Would you
of
even
this.
attempt to appeal that after understanding it the way you do now?
I would, there's a lot more involved that I don't know about. I mean, I wouldn't 2 months. I have no idea. But how are you going to? The only thing you could do is try to penetrate that common enterprise element. And I don't know if you can overcome Edwards and remember the light most favorable to the winner
Yeah.
on everything. So Ripple, if I'm the lawyer, I'm like, Ripple, give your 750 and move on. That 750 is going to be like, it's going to be, it's going to be the same amount of money as you're going to pay me to appeal it, because the value is going to go to the moon here pretty soon.
Yeah.
Maybe.
I'm pretty sure about
Programmatic sales. And so then we would think about this in terms of the light most favorable to Ripple as to whether the SEC would appeal. And they know this. Believe me, they know that rule. And so they're going to think about that. Would they try to appeal it? Maybe, but it's light most favorable to Ripple on this one.
Yeah.
So they might just call it a wash as between the both of them. Maybe they'll just say, okay, Brad and him acted recklessly. So what? What are they going to fork over? It's the same institutional sales money.
Right.
Some kind of slap on the wrist. Bad boy. Don't be bad boys again.
Yeah.
Okay. Let's move on.
Yeah. Now that we're a global company, we don't have to worry about doing that again.
I don't care. We don't care. I think they move on.
Yeah.
But I don't know. Programmatic sales. The court next addresses programmatic sales, which occurred under different circumstances. Okay. This is the SEC's allegations with respect to this only. Programmatic sales to public buyers. Okay. On digital asset exchanges, Ripple understood that people were speculating on XRP as an investment. Of course we were. Of course I was. Explicitly targeted speculators through their brochures. So what? And made increased speculative volume a target goal. True. All true. Having considered the economic reality of the programmatic sales, the court concludes the undisputed record does not establish the third Howey prong. So remember, in the first institutional sales, she went after all three elements.
Right.
Here, she's saying, I'm only taking a look at the third prong. Why? Because it's not met. The SEC didn't meet its burden. So she's saying, since you have to prove SEC all three,
right,
and you can't meet this one, I'm cutting loose for myself on the other two. I'm not saying you have proved them. I'm not saying you haven't proved them. Right. I don't have to even tell you about it.
Right.
So don't go out there speculating, audience, or listen to other YouTubers that say the judge said there was no investment of money. The judge said there was no common enterprise. She hasn't said that. Okay. She hasn't said it was. She hasn't said it wasn't.
But the beautiful part is the ones they lost aren't going to affect anything going forward.
Rephrase. Sorry.
If they go forward, okay, and the two prongs that are in question,
yeah,
okay, aren't going to stop Ripple from becoming, or XRP from becoming what it wants to be ultimately.
No, the program, because one element isn't met, the whole thing, that whole programmatic sales allegation is thrown out of court.
Right. What I'm trying to say is they couldn't come back and build a brand new case against the next company with just those two elements.
Oh, they can come back. They have to prove all three elements against the next
lawsuit. And once that element is rock solid, we'll say temporarily.
This isn't rock solid anything, unfortunately, and that's another misconception in the community.
Very lighthearted.
Okay.
But
it only applies to Ripple.
Yeah, but the plan of attack is there.
It's different facts, though, for every company. For every case, it's going to have different facts.
Maybe.
This element,
yeah,
I see what you're saying.
Is covering everything.
This element, blind bid ask, but no other judge or appellate court has to follow her ruling. This is persuasive authority only.
Yeah.
Okay.
Okay.
So you'll hear a
But-
lot of people in the community saying, this is now law of the land. It's like, this is persuasive authority that another judge could rely on. That's it.
Right.
Okay.
Yeah. But the SEC has no authority to go in and fine Ripple for any of those actions going forward.
No, this will not be part of the remedies phase
Right.
of the case. It's out.
Yeah.
It's out. But I like it to go over it because it's important to understand
It is. Yeah.
why, again, this is bolstering my arguments that I repeated in a couple of videos, and I'm repeating today because it just keeps going and going. XRP is a security. It's not a security. It's like, okay, all this together, read the tea leaves between the lines, should give you the comfort knowing we're done. It's done. This is all that's left in this case is some procedural stuff.
There's no way again, Gary can't get a, Mr. Burns moment and decide to slap a whole brand new lawsuit.
No.
Different
There's
material.
an affirmative defense on that. Yes.
Okay.
This is it. And the statute of limitations and everything else. No, you don't get a second bite at the apple. You have to have it all
Right.
pled.
Okay. Right. That
Yeah.
makes sense.
Once you go forward, you can't just keep suing for the same thing. Can't remember what it's called, but you can't do that. One bite at the apple. Okay.
Mm-hmm.
Good question, though. Having considered the economic reality of programmatic sales, so no, they can't come in and try to bring some better evidence or fix what Judge Torres said was bad about it. They are stuck with this, and they're stuck with these facts on appeal as well. And they know that.
Yeah.
Okay.
It's on the record.
Having considered the economic the court concludes not established, whereas the institutional buyers reasonably expected that Ripple would use the capital it received from its sales to improve the XRP ecosystem and thereby increase the price of XRP, kick. Programmatic buyers could not reasonably expect the same. Indeed, Ripple's programmatic sales were blind bid-ask transactions, and programmatic buyers could not have known if their payments of money went to Ripple or any other seller of XRP. Very important. So when you're thinking about these people out there on YouTube and Twitter space going, XRP's still unknown if it's a security or whatever, just think about it. Who cares? Just get your XRP, wait to go to the moon and buy your Lambo. And that's what's going to happen. Okay. Yeah. Maybe. I don't know about the moon, but therefore, the vast majority of individuals who purchased XRP did not invest their money in Ripple at all. And that's a lot of what the people were saying.
Right.
But I didn't even know Ripple, blah, blah, blah.
Yeah.
Okay. And the judge recognized that. An institutional buyer knowingly purchased XRP directly from Ripple. The institutional buyer knowingly purchased XRP directly from Ripple, pursuant to a contract. But the economic reality is that a programmatic buyer stood in the same shoes as a secondary market purchaser who did not know to whom or what it was paying its money. And by the way, these programmatic buyers, they're one step above us. These are not us, secondary market holders. These are not XRP holders like us. This is another level, which I can't remember the facts, but it was that this was about the underwriter thing or whatever. This is one level above us. Okay.
Yeah.
Even, but below the investment buyers.
Market makers.
16. Right. There you go. The court does not address whether secondary market sales of XRP constitute offers and sales of investment contracts, because that question is not properly before the court. Remember my videos that I went over, the library video and the other one showing what the SEC alleged over Ripple?
Yeah.
And I showed you where the SEC was saying, we're not alleging that. Whether a secondary market sale constitutes an offer or sale of an investment contract would depend on the totality of circumstances and the economic reality of that specific contract, transaction, or scheme. And remember her subject of the investment contract is not necessarily the security. Further, it is not enough for the SEC to argue that Ripple, quote, explicitly targeted speculators. So what? What Howie element is that? Or that Ripple understood that people were speculating on XRP investment. So what? What Howie element is that? Because a speculative motive on the part of the purchaser or seller does not evidence the existence of an investment contract, i.e., what element are we dealing with here, people? None. And I don't recall this case at all. So a case that she came up with, I'm not sure. I do remember Merrill Lynch, but anyway, this is out of her court in 1966. Okay, so to say that we don't know about this stuff is poppycock. But anyway, anyone who buys or sells, for example, a horse, and this is Alan's example, or like a item of artwork at Christie's, or an automobile, hopes to realize a profitable investment, but the expected return is not contingent upon the continuing efforts of another. Okay, and then she's citing that case, that Merrill Lynch case, and citing Joyner, which is another United States Supreme Court case. And this case was relied upon by Ripple. So that was good. The relevant inquiry is whether this speculative motive, quote, derived from the entrepreneurial or managerial efforts of others. Foreman, it may certainly be the case that many programmatic buyers purchased XRP with an expectation of profit. Okay, the third element, but there's two parts to the third element, but they did not derive that expectation from Ripple's efforts. Okay. As opposed to other factors such as general cryptocurrency market trends. And we know sometimes the markets sort of moved together at times, and other factors that we discussed in the expert witness order review that we did as well. We were looking at some of those datas and the blah, blah, blah from all those doctors, the PhDs. Okay. None of the programmatic buyers were aware they were buying XRP from Ripple. Of course, some programmatic buyers may have purchased XRP with the expectation of profits to be derived from Ripple's efforts. However, quote, the inquiry is an objective one focusing on the promises and offers made to investors. It is not a search for the precise motivation of an individual participant. Here, the record establishes that with respect to programmatic sales, Ripple did not make any promises or offers because Ripple did not know who was buying the XRP and the purchasers did not know who was selling it. In fact, many programmatic buyers were entirely aware of Ripple's existence. Lacked other factors as well, which cut in favor of reasonable expectation element. Programmatic sales were not made pursuant to contracts that contained lockup provisions, resale restrictions, indemnification clauses, or statements of purpose. Similarly, Ripple's promotional materials, such as the Ripple Primer Gateways brochure, were widely circulated amongst potential investors like the institutional buyers, but there is no evidence that these documents were distributed more broadly to the general public, such as XRP purchasers on digital asset exchanges. And that's one of the things that the lawyer said on Crypto Aries channel, like, oh, we knew that the brochures were there. And it's like, yeah, lawyer, but there's no evidence before this judge that we got any brochures. Okay. So no evidence, no appeal. Right. Nor is there evidence that programmatic buyers understood that statements made by Larson, Schwartz, Garlinghouse, and others were representations of Ripple and its efforts.
And you can't submit new evidence on the appeal.
Nope, which was why I was shocked. I shouldn't have said she was idiotic on the live stream, but anyway, I regret that one. But it's appeals 101. So I don't understand the deal here. The judge is saying there's no evidence before me. Where's the evidence? SEC, you blew it. You didn't bring me any evidence. Lastly, institutional buyers were sophisticated entities, including institutional investors and hedge funds. An examination of the entirety of the parties' understandings and expectations, full set of contracts, expectations, understanding, so on and so on. We talked about that above. It was all there. right? Remember,
Right. Yeah.
pages of evidence. Here, there is no evidence that a reasonable programmatic buyer who is generally less sophisticated as an investor shared similar understandings and expectations and could parse through the multiple documents and statements that the SEC highlights, which include statements sometimes inconsistent across many social media platforms and news sites from a variety of Ripple speakers with different levels of authority over an extended 8-year period. So we didn't sign. It's not even us. We're not these programmatic buyers, by the way. It's a,
Right.
like you said, it's some institutional exchange or something. Okay. So out, doesn't meet the investment contract. And then again, she says here, because you don't get to the third prong,
Right.
you don't, she's not going to bother with the other stuff. Okay. Other distributions. And this one is just really simple, no investment of money. Okay.
Yep.
So there was no investment of money. Sorry. The other distributions to the employees.
It was coins.
The employees
Yeah.
got some, they donated some, they funded other projects and things like that. And the SEC tried to argue, well, they might sell them and get money, but the prong says investment of money. And she said, not there. And so you know what she says about the rest? You know that she says, once she says that one prong is missing, I don't care about the other two prongs. And we're moving on. So SEC loses that. Larson's and Garlinghouse's offers and sales. These were, they tried to say they have an exemption. Like Ripple's programmatic sales, Larson's and Garlinghouse's XRP sales were programmatic sales. Okay. So we know what,
how she feels about that.
I went through the long version of programmatic sales so we can truncate this. Okay. Didn't know the identity, a matter of law, can't establish that. The due process defenses, this was fair notice, and she's very clear on this. And this was my position. Alan knows this all along. He wasn't happy that I had this position, but I said I don't know about fair notice. I'm not sure. But defendants each assert a fair notice defense claiming the SEC violated their due process rights and the as-applied vagueness defense. Okay?
Yeah.
And the court rejects defendants' fair notice and vagueness defenses. And I'm going over this because we had the big kerfuffle over the Hinman. Hinman, we win. XRP isn't a security. And Hinman, and all this. And it was like, and Alan and I did that show, and we kind of got some flack for saying, well, I said nothing burger. And then Alan's like, yeah, we kind of know all this.
I was on Lewis's show and called it a nothing burger, and he even agreed. He's like, yeah, we didn't get much out of that.
Yeah. I mean, it was juicy. We agreed it was juicy. From my standpoint, though, it didn't have anything to do with the lawsuit. And remember, we did our famous footnote video on it.
Also, I heard somebody say that we didn't get all of it either. There was still redacted stuff in it.
It was redacted as per her order to keep certain things private.
Which was probably very incriminating for the SEC.
It was just the names and things. No. I'd like to see it. Can I see it rather than just somebody's hearsay statement about it first?
Well, no, I only bring that up because what Hinman has said since is,
well, a man can change his mind.
Right.
All right.
And the great part about Hinman was he knew more about this stuff than any of the other directors.
And that's fine. But
and
it
he's
doesn't.
The one that was saying they weren't securities.
Inapplicable because nobody ever saw those emails in making their decisions one way or the other. So she'll come and let you know about that. She rejects it as to all of them. And it only applies now to institutional sales.
Right.
Okay. It doesn't apply to programmatic or other because I'm throwing those out.
Yeah. Okay. And as long as we have exchanges or over the counters, there's no need for an institutional sale going forward.
Well, unless you want to fund your stuff. But yeah,
they would fund your stuff by selling it on an exchange.
Oh, through the programmatic sales. Right.
Yeah.
That's right. Yeah. So that might, piss off the SEC, but
that's why they're trying to get rid of the off-ramps.
You see, Ripple's got the common enterprise thing, she's a little light on that. And the SEC has programmatic sales. Not as light as common enterprise though, but yeah, I think they both have sort of a bargaining chip there. It's sort of a wash. They're going to wash each other out and they're going to be right back to where they were. So first, the case law that defines an investment contract provides a person of ordinary intelligence a reasonable opportunity to understand what conduct it covers. Okay, Howie sets forth a clear test for determining what constitutes an investment contract, and Howie's progeny provides guidance on how to apply that test to a variety of factual scenarios. It is not only the language of a statute that can provide the requisite fair notice, judicial decisions interpreting that statute can do so as well. That is constitutionally sufficient to satisfy due process. I looked at this case, this Zaslavsky case. I didn't get to it, I don't think. The abundance of case law interpreting and applying Howie at all levels of the judiciary, as well as related guidance issued by the SEC as to the scope of its regulatory authority and enforcement power, provide all the notice that is constitutionally required. And that's from 2018 in this Zaslavsky. Second, the case law articulates sufficiently clear standards to eliminate the risk of arbitrary enforcement. Howie is an objective test that provides the flexibility necessary for the assessment of a wide range of contracts, transactions, and schemes. This is all coming up, folks. This is all being raised again. We've got Bittrex, we've got Binance, we've got Coinbase, we've got Dragon Chain, we've got somebody else.
What they're doing is they're slowly creating an authority of the system over a completely new industry. Because now you have people who own XRP who agree with the SEC or the laws that have been ruled upon. And now you have millions of people around the world going, yeah, the law's on our side. Now the law becomes part of the crypto sphere. It's very invasive, but because people are profiting, they'll accept it. It's not why crypto was created.
Just give me my Lambo.
Exactly.
Okay.
And the problem is that we're giving them authority over our coin or our industry that does not. It fights authority.
Well,
the fact that you don't need authority is the whole concept of cryptocurrency.
Well, you don't need authority. It's the same. You have
Be your own bank.
Those strong feelings as I have too. If everybody just didn't get on a plane instead of getting those experimental pharmaceuticals injected into their bodies, they would shut it down in 3 days. You say, I say, a little longer, but but they don't, because we want our Lambo. We want to travel to Hawaii, whatever.
Yeah.
Let me go off. I went off on a tangent. The SEC's approach to enforcement, at least as to the institutional sales, is consistent with the enforcement actions the agency has brought relating to the sale of other digital assets to buyers pursuant to written contracts, citing Telegram. The law does not require the SEC to warn all potential violators on an individual or industry level. This is a Second Circuit case out of 2010. Quote, courts ask whether the law presents an ordinary person with sufficient notice of or the opportunity to understand what conduct is prohibited or prescribed, not whether a particular party actually received a warning that alerted him or her to the danger being held to account for the behavior in question. Accordingly, denied. Fair notice is thrown out by her. Larson's and Garlinghouse's aiding and abetting of Ripple's violations. And so this is, I'm going to go through these so you understand a little bit about it. The SEC also, because you're going to have this coming up. We got Binance, we've got whatever, we got all these cases. So soon our viewers will have a compendium of stuff that they could go to. The SEC also moves for summary judgment on its aiding and abetting claim against Larson and Garlinghouse To establish this liability, here's the elements for aiding and abetting. The existence of securities laws violation, we have it above, see above, okay? Knowledge of this violation on the part of the aider and abetter, we're going to discuss that. Substantial assistance, okay? Courts cannot consider the three requirements in isolation from one another because satisfaction of the knowledge requirement will depend on the theory of primary liability, and there may be a nexus between the degree of knowledge and the requirement that the alleged aider and abettor rendered substantial assistance. And I think this is why this is a jury question. She's having to make too much of a judgment call. It's not an undisputed fact about their, and she says it's not their state of mind. The scienter isn't applied, but it's this knowledge thing. So let's go there. I get confused between scienter and this other thing. And a lot of other lawyers do, because I've seen it in cases where they conflate the two concepts, but they are tricky. But courts have found a high degree of substantial assistance may lessen the SEC's burden in proving scienter and vice versa. I think the scienter is this knowledge. And see, I'm even conflating it. But anyway, so she's just saying you need sort of all three. It's kind of like my parole hearings. You know, you've got these Title 15 factors. They can rely on one thing. They can look at it. They're supposed to look at it as a whole picture, not just one thing, right? Oh, I'm discipline free. Yeah, but you know, didn't take any self-help classes or whatever. Denied. But I'm discipline free. And so it's kind of like that. You don't have to, they want a whole picture. As to the first requirement, she said, we've decided that. With respect to the second requirement, general awareness of their overall role in Ripple's illegal scheme. What she's talking about here is the violation, that now established violation, okay? The SEC need not demonstrate that Larson and Garlinghouse were aware that Ripple's transactions and schemes were illegal. That's where I get confused.
I do too.
I get confused there. If they're not aware that they're violating the law, then how can they be recklessly disregarding it? Rather, the court must show, the SEC must show that Larson and Garlinghouse knew or recklessly disregarded the facts. Knew or recklessly disregarded the facts.
I don't know how they're going to prove that.
Which one is worse? So I think, can you see why this has become a trial issue? She's like, how am I going to decide this? How am I going to point to the undisputed facts here? Again, another smart. I think it fits.
They're going to pay the fine at the courthouse steps, right?
I would think they just want to move on.
Yeah.
Yeah, and they're what fine? Because it's the same 757 million from the institutional sales, right? That they aided and abetted.
Yeah.
So they didn't get anything. They just aided and abetted Ripple in doing it.
Yeah.
So it's nothing. I think this is a nothing. This is a washout. The facts that made Ripple's transaction schemes illegal, blah, 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 based on the record, raise a genuine issue of material fact, whether they recklessly disregarded. It is not clear whether Larson and Garlinghouse knew or recklessly disregarded that securities laws, rather than laws under other regulatory regimes, applied to XRP. For instance, Larson and Garlinghouse testified that they did not believe XRP was a security because multiple foreign regulators, including regulators in Japan, Singapore, Switzerland, United Arab Emirates, and the United Kingdom, had determined that XRP was not a security, but they don't have Howie.
And now Europe.
L&G also stated that when the U.S. Department of Justice and the U.S. Treasury Department's Financial Crimes Enforcement Network labeled XRP a virtual currency in 2015, they understood this as an official United States government declaration that XRP was a currency and exempt from securities law. I really like that fact for the two.
Well, we've been saying that for 2.5 years.
I like that fact for them.
For 2.5 years, we've been saying that.
Larson further testified that he understood the 2018 speech by Hinman, in which he stated that neither Bitcoin nor Ethereum were securities, to further reinforce the SEC's position that XRP was not a security, but not the sale and offer of it in exchange for money to fund their operation. So who knows? The October 2012 Perkins Coie memorandum, which Larson reviewed, advises, although we hello buddy although we believe that a compelling argument can be made that XRP tokens do not constitute securities under the federal securities law, given the lack of applicable case law, we believe there is some risk, albeit small, that the SEC disagrees with our analysis. That's a letter they got. They got at least one or two other letters from lawyers that advised in whatever way. I don't remember. I have read the evidence, though there are those letters. Larson, and she just picked one. Okay, she's not picking a whole bunch of facts because she's saying she's punting. I'm like, I'm washing my hands of this issue.
Yeah.
So Larson testified that after receiving the memo, the Perkins Coie, is that the one where that Podesta guy worked at?
Yep.
Oh, okay. Well,
that's the
okay
one that how was the other guy? James Comey, wasn't it?
Oh boy, you coming up?
The whole Southern District.
Coming up to say hello? Okay. Hello, buddy. Hello. Speak into the camera.
That whole bunch.
Speak, buddy. There you go. Okay, he's a good
That
boy.
whole bunch from the Southern
What is
District.
with you and the cameras?
Pretty.
What is with
corruption
you?
kind of.
What do you need? Do you need some hugs? Okay, we're getting to the end of this. This is okay.
Yeah,
that's a good boy.
Speaking of,
he's a good
boy. We had a Secretary of State. She was who took a hammer to a hard drive. Who was a 40-year attorney, and she didn't understand the meaning of intent.
I didn't have sex with that woman.
Well, stop and think about that statement that they let her go. She didn't understand intent, was what they let her off on. And these guys are expected to know that that's a security.
Okay. And genuine issue of material fact. I don't know. He got all worked up about the cameras again. Okay. Yeah. Now he's going down. Okay. Goodbye, buddy. He's biting me. Don't bite. I don't want no bites. No biting. Larson testified that Larson testified after receiving the memorandum, Ripple took specific steps to ensure compliance with the advice contained within the memorandum. I don't know. I don't know what that testimony or that evidence is. It doesn't matter. She's sending this to trial. Defendants have raised a genuine issue of material fact as to whether Larson and Garlinghouse knew or recklessly disregarded facts about each of the Howey elements. For example, defendants have adduced evidence that Larson and Garlinghouse did not know that Ripple's institutional sales of XRP satisfied the Howey, quote, common enterprise element because they did not believe that the proceeds from the sales were pooled and understood that Ripple did not manage, operate, or control the XRP ledger. All right. Well, she's saying maybe. And there's that common enterprise stuff again, and it was tricky. Based on the disputed facts, reasonable jury could find they didn't recklessly disregard the rules. And as to the third requirement, defendants concede that Larson, as Ripple's CEO prior to 2017, provided substantial assistance, and Garlinghouse, after becoming Ripple's CEO in 2017, provided substantial assistance. However, Larson claims that he did not provide substantial assistance during his time as executive chairman. To satisfy the substantial assistance component of aiding and abetting, the SEC must show that the defendant in some sort associated himself with the venture, participated in it as something he wished to bring about, and that he sought by his action to make it succeed. In other words, the defendant must consciously assist the commission of the specific crime in the active way. Larson has raised a tribal issue material fact as to whether he provided substantial assistance beginning in 2017. Larson moved away from day-to-day operational role. After that, he stepped down, continued his role, which approved Ripple's sales. The court concludes, therefore, that a reasonable jury could find that starting in 2017, Larson did not consciously assist Ripple's violations in some active way. I don't know what happened to Garlinghouse and the substantial assistance. Is Garlinghouse conceding that issue? I don't know what to tell you guys on that. So they're going to trial for sure on the knowledge.
Yeah.
Okay. They're going to trial on the third element for larceny and question mark on Garlinghouse. And I don't think it matters too much.
No.
And they're going to set a trial date. Okay. The court's going to issue a trial date and pretrial deadlines, which should be interesting because if they go courtroom steps, then there's going to be a bunch of motions in limine, and we can see all kinds of juicy stuff that they want to keep out that they don't want a jury to hear about. And so hopefully we'll get to see that stuff and it won't be redacted. And I did want to comment at the end of this, bring up the Clintons and the trial.
I didn't say Clintons. You said Clintons.
And I'm sorry about that. I hate to use that 4-letter word, but the video, the Jim Caviezel, interestingly enough, I heard there's a very well done clip by this guy that works for Alex Jones, and he does these monologues, and he puts this condensed facts together. It's a very sharp guy. I don't remember his name. It's at the beginning of the last lengthy Alex Jones show. It's at the very beginning though. And he says there's a connection to, so there's always these conspiracies though. And we go, oh, this movie's great and everything. So he's saying, please support this particular organization. And that particular organization is tied directly to the Clintons and all of their shenanigans that they've been doing with child trafficking. So thank God this is on Patreon. Happy little Sunday topic. What do you want to end with, Alan? We made it. We did it.
We did.
We did it.
Don't push any buttons.
Oh, no, I'm not pushing no buttons. I hope this recorded.
Yeah. What I'd like to end this with
Same amount of time as the other video.
More consistent.
I tried to keep it shorter.
We're turning the page. The book isn't closed yet on this case, but it sure looks like we're at the final pages. And this, I don't even know that the media is going to follow the next part of this case. Do you? I mean,
no,
they won't really. It'll be court.
The media, no. The Twitter steps. Chicken coop crap. Yeah. Yes, they've got to keep this going. I mean, look how they had to. Well, I mean, we talked about it, but I was trying to figure things out because everybody was so panicked about losing and what was going to happen.
I was going to do a conclusion video, and I still probably will.
You should.
But I just want to kind of say this one thing. Everything that thing said is exactly what we were talking about 2.5 years ago. Exactly. Like almost to the T. It's amazing to me that it's
funny. I couldn't find any of that from 2.5 years ago.
Well, I mean, the fact that it wasn't an orange and we were saying that it wasn't,
came full circle.
We didn't know we were buying from Ripple.
Didn't know we were buying from Ripple.
All of those things we've been saying for 2.5 years. Mm-hmm. And she figured that out. She actually, saw, hey, wait a minute, because she could have looked past that and just went, hey, you people knew what you were buying. You were buying from Ripple.
She has to cite the evidence though. So
yeah. Okay. But
she has to see how she cited almost everything.
Yeah.
That's a very thorough judge.
But she didn't cite, she ruled on a couple of things, mentioned on
her legal department is very thorough.
Yeah. She mentioned a few things that she didn't have to put in there that was kind of feather in our cap.
Like what?
I knew you were going to ask. Not fair notice, but secondary market.
She mentioned it because she had to.
Didn't we do 2 shows saying that she wasn't going to rule on that?
Yeah, she says, I'm not going to rule on it because it's not before me.
Right.
Yeah.
But she did talk about it.
Okay.
Yeah. That's what I'm saying. She didn't have to do that, and she did. That's my point.
Well, she has all the amicus stuff harping at her.
Yeah.
She has 15 amicus briefs. 2 were in support of the SEC.
Everything that I'd heard about the judge prior to the trial, when we first found out which judge we were going to get, everybody went through her with a fine-tooth comb. I just remember a month and a half straight of YouTube channels talking about virtually every case she'd ever tried, and splitting hairs about this and that. And
she's hardly done any SEC cases.
Right.
A lot of environmental and ADA, Americans with Disabilities Act cases.
And she did that big case for the prisoners in the state of New York, which showed her compassion in her heart. And I think it kind of showed in this ruling, and it came out that she was a good person. She is a good person. She did care about people.
She's not corrupt. She's not on the take.
Yeah.
Because if she was on the take, it would be all in favor of Ripple.
Yeah. But I really believe that, like, in particular, Jeremy Hogan was instrumental for a very long time in talking about who this judge was. Like he almost knew her. I don't think that he did. Maybe his dad did. His dad's an attorney. But it almost felt like he knew how she was going to rule. And it's kind of the way she ruled, which is never the case when somebody on YouTube gets on there and they talk about this and this and that. It was pretty interesting to me the way the day happened of Thursday. When the day came and the verdict, or it was read, if you will, we all came to pretty much the same conclusion of, oh, this thing is over. It wasn't damn, we're splitting the baby, which is kind of what they did.
Split the baby, kind of.
They split the baby. Only
but she split it in a way that
they got a terrible half of the baby.
This is done.
They got
a pound of flesh out of them. And
they're going to get money out of it.
They were allowed to relist XRP.
Yeah. They're going to get money out of the deal.
Well, not allowed to, but they're taking a chance on because of her ruling to say she walked you through it. She said the subject of the investment contract is not the security.
Right. They're going to get money out of the deal, but they're not going to get any control of XRP out of the deal. None. So they got the short end.
They might have to disgorge something. I don't know what. Maybe this escrow, the ones in escrow. Your viewers were asking about that, I think.
No way they're going to give them those. No
well,
way.
It's whatever they're going to go do the remedies phase, which will be interesting. Yeah, but you're
not going to penalize them more than what they sold. How could you do that? I don't know.
Oh, you have the penalties. You have the disgorgement, and then you have the penalties.
Yeah.
Yeah. She's not going to. She's not.
Well, there's way more in escrow.
She's not going to. She's not going to penalize all that, but she might. She might.
All right.
Okay, we did it, guys. We made it even longer than the last one. How did we manage that?
I don't know.
All right. Thank you, guys. Sorry about the goof up, and we'll see you soon.
Yep. See you soon, guys.
Okay. Next Sunday, for sure, Alan and I will be here, and Alan with other videos. Hopefully he's got some juicy content for Patreon.
I do. I have some good stuff coming up. I know I said that last week. I'm rebuilding my whole office. I wired it. It's really been a big project, and it's been really hot. So
really hot.
I've really been working on it hard. Sorry that I haven't been spending as much time with you guys, but I do promise to do so coming soon.
He's got a slave driver over here.
Yep.
Okay.
All right, guys.
Bye-bye.
Love y'all.